Let me begin by thanking the proprietors of Law Pavilion and the TELNET Group for the very kind invitation to make these remarks at this very unique legal technology conference. As I congratulate you on this landmark gathering that you have boldly described as a new paradigm in justice delivery, let me at least make a partial, if not a full disclosure. My former law firm and a group of other law firms, have been partners with Law Pavilion for many years. And I've watched very keenly how through the years the company has blazed the trail along with other legal technology companies in innovating for our administration of justice system. Almost on a yearly basis, the team at Law Pavilion have consistently introduced new technology products for justice delivery. We're all extremely proud of your resourcefulness and the hard work that you have put behind all of this through the years. Our world has changed dramatically. In March this year, with the COVID-19 pandemic, something happened that clearly redefined everything that we knew to be normal. No nation was prepared for what we're experiencing today. First, a lockdown. Our movements restricted within the walls of our homes. And even as that eased, it appears that with social distancing and the rules against crowded spaces, and there's so many new rules now, the world is set for a new paradigm defined by very limited human interaction. It's a paradigm that technology innovation appears to have predicted. When years ago, the likes of Law Pavilion and TELNET Group went from state judiciary to state judiciary, preaching a message of technology-assisted processing of cases, including virtual court proceedings, they seem to be literally living in the clouds, if you will pardon the pun. No one believed the day would come when the Supreme Court would, as it has now done, endorse virtual court proceedings, or that the day will come when e-filing of court processes will be considered even medically safer than physical filing of court processes. Even judges today will of course prefer virtual processes in any event because no one wants to be in a crowded courtroom. With all the jokes and the vicious jibes against lawyers, no one ever predicted the ultimate irony of compulsory mouth covering for advocates in court. No one ever predicted that. Such is the time that we're in. So we're at a fortuitous but incredibly auspicious convergence in human history. Technology and the fourth industrial revolution are no longer luxuries, but they are the inevitable substructure of our new way of life. For the administration of justice system, change has surely come. And I'm personally excited to see how easily our entire judicial system is willingly adapting to innovation. First, only a few weeks ago, as I noted earlier, the Supreme Court endorsed virtual court proceedings. The reform of adjectival laws, all that rules of procedure and laws of evidence, is a far-sighted one because years ago, we embraced electronically generated evidence, and our courts have also made several favorable pronouncements, opening the way to a more favorable attitude to the use of technology tools in procedure and in proof. The next few years, we are bound to see even more changes, and I dare say even the next few months. Artificial intelligence, or just simply AI, will play a bigger role in our court systems. I'm told that Law Pavilion is already pioneering an AI-powered text transcription system, powered speech-to-text transmission system. In other words, a system that replaces writing in longhand or even the traditional stenographic recording and simply just transcribes speech to text so that the judges no longer need to rely on long handwriting or even recordings from the stenographers in courts. They can now simply have their own speech just translated almost immediately or transcribed almost immediately into text. They also have the AI-powered document review system that helps judges quickly extract authorities and laws that are cited in any legal documents, and then outlines and analysis of principles that are relied upon, that are relied upon in the text. So now there is facility that allows that allows judges to simply, by introducing written material into these systems, they can quickly analyze laws, quickly analyze cases that have been cited in those documents without human involvement, just using artificial intelligence. And this is, of course, aside from the comprehensive court proceeding software that they have now perfected. Your Excellencies, my lords, whether we like it or not, nothing can ever be the same again. Legal practice is also in a flux for those of us who are lawyers. Artificial intelligence will make research 1,000,000 times faster. The lawyer may no longer be required for several categories of legal advice. There are already apps that are updated to the latest positions in legislation and case law. So it is already, all the sorts of advice we used to ask for before, that clients used to ask for, where clients will say, tell us the legal position with respect to taxes in Nigeria or with respect to the business environment. That is already now available in applications. People can ask questions from all sorts of intelligence systems that can tell them the answers to these questions. So the lawyer can no longer just be a technician. He can no longer just be somebody who looks up the law and tells others what the law is. The lawyer, as I said to a group of young men and young students of law last week, must become a multidisciplinary, multitasking, technology-savvy person of affairs. That's what the lawyer must be now. The lawyer can no longer afford to just be a technician of sorts. The democratization of law and justice is now on fast track. So the question that we should ask ourselves is, what should we be doing now? And I think that is already being answered by tech companies like Law Pavilion. Because one thing is that they must innovate even more. We must now have purpose-built virtual proceeding software that take into account the various needs of trials and other court proceedings. By that I mean that you may no longer be using software like Zoom and other, other all-purpose virtual meeting software. We now need our own type of software that is adapted specifically to court proceedings, that enables us to do the things that we would do physically, virtually, and that is specifically designed for courtrooms. This sort of innovation is where we expect our tech companies to go now. There will be opportunities for retraining of judicial personnel, retraining of lawyers and paralegal staff. The new normal calls for new skills and new ways of doing old things and doing away with many old habits. Already, my Lord, the Chief Justice, has set the example of adaptation to the new paradigm. This is my second virtual meeting with my Lord, the Chief Justice, in barely 4 days. So if my Lord, the Chief Justice, who represents, not just the new, but the old traditions of the judicial system, is ready to adapt so quickly and is adapting so well, then shame on us, the rest of us, if we don't adapt very, very quickly to all that is going on. Let me say in conclusion that the federal government of Nigeria is committed to doing everything possible to support tech companies, especially those that are concerned with the administration of justice system. If you look at the economic sustainability plan, there is a whole section devoted to innovation. And I think that as much as possible, tech companies such as Law Pavilion and TELNET Group should take advantage of some of the offerings in the economic sustainability plan, and also in the current work that the Ministry of Communications and Digital Technology is doing. There is so much opportunity for collaboration with government at this time. So again, just to congratulate Law Pavilion and the TELNET Group on this conference and bringing us all together to look at how the new normal will play out and what our roles will be in this new normal. Thank you very, very much once again for the kind invitation. God bless you all. Thank you.